Major breaking news. The Firearms Policy Coalition has brought a major lawsuit in the United States District Court for the Northern District of Texas challenging quote-unquote sensitive places laws in the state of Texas that apply basically to bars, to racetracks, and to sporting events. Let's talk about this lawsuit and what are the chances of it winning down there in the Northern District of Texas. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the new law review article in the Georgetown Journal of Law and Public Policy associated with the Georgetown School of Law. The title of the article is Dangerous but Not Unusual: Mistakes Commonly Made by Courts in Post-Bruen Litigation. It's about 60 some odd pages long. A very detailed analysis, very geeky, very scholarly discussion of how to apply the Second Amendment in modern day litigations. If you're a law clerk, a lawyer, a historian, a scholar, a judge, or anyone interested in the context of understanding the Second Amendment and in litigation, it's certainly an article that's worth checking out. I'll put a link to it down below in the description of this video. All right, folks, so we have a major lawsuit we have to report on out of federal court in Texas. The Firearms Policy Coalition, with some other plaintiffs, have sued the state of Texas, challenging three quote-unquote sensitive places. As you know, a sensitive place is a euphemism. It is a euphemism for what it really is, which is a government-mandated gun-free zone. Now, we're going to talk about the legal standard here in just one second, but I'll give you a quote from Brandon Combs, the president of the Firearms Policy Coalition, summarizing why they brought this case and their views on it right here and right now. The Firearms Policy Coalition has already struck down Texas's ban on firearm carry for adults under the age of 21. We now set our sights on ending enforcement of these locational bans so that all peaceable adults may carry firearms in public places without fear of criminal prosecution. This case is one of dozens we are litigating to help us achieve our strategic objectives and eliminate unconstitutional and immoral carry restrictions throughout the United States, explained Firearms Policy Coalition President Brandon Combs. Powerful language there by Brandon Combs, and I couldn't agree more with the goals of what they're articulating in this particular case of Ziegenfuss versus McCraw. McCraw being the director and colonel of the Texas Department of Public Safety. Now, as you know, in Heller and in Bruen, there were reference to these things called sensitive places, but they haven't really been fleshed out in a great way. In Bruen, they specifically did say that you cannot declare, let's say, Times Square or the island of Manhattan to be a sensitive place simply because there's a lot of people present and there's kind of law enforcement meandering around. That's not enough to make something a sensitive place. The only three examples of sensitive places articulated in Bruen was very specific, and that is polling places, that is courthouses, and that are legislative chambers. Now, if you look historically, and I talk about this with extremely detailed historical facts, in my article in the Georgetown Journal of Law and Public Policy, linked down below, totally for free, just link and click on from Georgetown, I go through a list of what makes polling places, courthouses, and legislative chambers sensitive. And what makes them sensitive places is not politicians just putting a stamp up or some sign up that says gun-free zone. No, that's not what makes something a sensitive place that can allow or constitutionally permit a government to ban guns in those locations. Constitutionally, historically, what constitutes a sensitive place or a place that can be a government-mandated gun-free zone is that the government takes on the responsibility of taking over your physical security, your physical safety. They basically say you don't need to protect yourself with your guns because we're going to protect you for you. We're going to protect you. Now, the most common example this pops up is when the police take you into custody. As you know, the basic black letter law in America is that the motto on the side of those police cars that reads "to serve and to protect" is not correct legally. There is no obligation by law enforcement in America to protect you from criminal activities by third parties. There is an exception to that when the government takes you into their custody and control, such as they put you in prison or the back of a patrol car. Then they do have an obligation affirmatively to protect you from bad people doing bad things to you, because you basically have been disarmed and are rendered helpless and are taken, basically you're in the control of the government. But absent that, there is no legal duty for government to protect you. A lot of case law on that, all the way up to the U.S. Supreme Court. There is no legal duty to protect you on behalf of government. You're on your own. Never forget that. So with that said, what constitutes historically a sensitive place? And if you look at the history of polling places, legislative chambers, and courthouses, as I talk about in my article in Georgetown, Journal of Law and Public Policy, I talk about how they all have one thing in common, and that is comprehensive security. Back at the time of the founding, they had deputies, deputy sheriffs, bailiffs, sergeant of arms. In other words, there were guns at these locations where people working for the government would defend the people that attended these locations with firearms. So it seems to me that the right constitutional answer today is, if the government wants to declare a place a government-mandated gun-free zone, they have to take on the responsibility of protecting you. They have to actually go through the actions of doing what they do with TSA. Single point of entry, metal detectors, armed guards. All of that has to be present in the modern world, as I see it, for something to be legally and constitutionally consistent with the Second Amendment as a government-mandated gun-free zone. And that is essentially the argument being advanced here in this Zeugenfuss case brought by the Firearms Policy Coalition down there in Texas. Now let's talk about that. In this complaint, they point out there's 3 specific sensitive places or claimed sensitive places they're trying to knock out. Businesses whose revenues or sales constitute more than 51% of the total sales of that business, or presumably what they're talking about is bars, because I presume that most bars have revenues from alcohol sales that exceed the 51% total of their total sales. And again, the rule here is that if it's a business in Texas that gets more than 51% of their sales revenues from the sale of alcohol, then you can ban guns there, or guns are banned there under the Texas state law. Also, racetracks, no guns allowed in sporting events. But there's no suggestion that there's comprehensive security in any of these locations. So let's turn and look at some of the arguments made by the plaintiffs in their complaint down there in Texas. The plaintiffs allege in their complaint, quote, "To determine whether a state's firearm restriction is constitutional, the court in Bruen," meaning the Supreme Court in Bruen, explained that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. Bruen has already established that the Second Amendment covers the plaintiff's proposed conduct here, which is carrying arms publicly for self-defense and other lawful purposes. As such, the Second Amendment presumptively protects the plaintiff's right to carry firearms in public in the state of Texas. So that's the basic law. You know that. And remember, the way to understand this conceptually in the abstract is the command, the unqualified command of the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed, is the legal, historical codification of long-standing pre-existing rights to protect yourself with firearms and weaponry of all sorts. Okay. But under the Heller-Bruen standards, it's true that despite that language in the Second Amendment, the government has an opportunity to come forward to show that there's some sort of regulation on the books today, right, that is being challenged, but those regulations today are consistent with some sort of a long-standing tradition of firearms regulation in the United States. And the example I like to give is this. At the time of the founding, when they adopted the Second Amendment, there were laws on the books all around the world and all 13 colonies, right, all 13 states, and so on, that you could not engage in cold-blooded murder. So you can argue that you have a right to keep and bear arms encompasses the right to commit cold-blooded murder. But how do we know that? Well, the way we know that is not because you say it or because you think it makes sense. No, that's not how you do legal analysis. The way we know that the right to keep and bear arms as found in the Second Amendment does not encompass the right to use a firearm in cold-blooded murder is because at the time of the founding, in 1791, when the Second Amendment was codified and adopted, every state had laws on the books that said you could not commit murder. So that would be an example where the Supreme Court would say, yeah, we have the textual Second Amendment right, but then the burden shifts to the government to show there's some sort of ban historically on murdering people with a gun, and we can show, the government could show at the time of the founding, that in every state at the time of the founding, you couldn't commit murder with a gun or otherwise. And therefore, they would use that historical tradition of banning murder to show that that is excluded or is an exception to the textual right of the textual right to keep and bear arms. Now, with that said, it's up to the government to show there is a historical tradition going back to the founding of 1791 when the Second Amendment was adopted to justify these so-called sensitive places laws in the context of banning firearms in businesses whose predominant business or predominant sales are from the sale of alcohol, presumably bars, from racetracks to sporting events and the like. And it's pretty clear that the government is not going to be able to do that for many reasons. One obvious one is we know that there was drinking and guns in places like Francis Tavern in New York City and in John Adams Bar Tavern in Boston as they talked about and prepared for and ultimately engaged in the revolution against the British. So there's certainly no history at the time of the founding that I'm aware of where you had a historical tradition of banning firearms in places where there was alcohol, especially if you were not the one drinking. And that's the key. These restrictions in Texas apply even if you're not drinking any alcohol. So if you go into a bar and you're drinking a Diet Coke, you still can't bring your gun in, even if you're not having a sip of alcohol. Now let's go on. So this complaint goes on to make this point about that it's up to the government to show an exception. They're simply not going to be able to do it here. This is what they allege in their complaint in Texas. It is thus the state of Texas's burden to affirmatively prove that its firearms regulation is part of a historical tradition that delimits the outer bounds of the right to keep and bear arms. If a state seeks to restrict firearms to a particular location as a so-called sensitive place, which Texas may attempt to do here, it must prove that its current restriction is sufficiently analogous to a well-established and representative historical analog. This analogical analysis is focused on determining whether the challenged regulation is consistent with the principles that underpin the nation's regulatory tradition. And again, the plaintiffs clearly argue that there's no way on earth that Texas is going to be able to pull this off because they're just going wavy, wavy, wavy. No guns allowed. Put up a sign, wavy, wavy, wavy. No, that's not how you do constitutional analysis. You actually are going to have to show, in my view, that to make these bars, racetracks, and sporting events analogous to what the Supreme Court has said is a sensitive place, which are polling places at the time of the founding, courthouses at the time of the founding, and legislative chambers at the time of the founding. What brings those three things together? And we know that, you can see the history in my article in the Georgetown Journal there. What pulls them all together is they all offered armed security paid for by the government. Is there paid for government security and all the comprehensive security appropriate for today's day and age in the bars, the racetracks, and the sporting events that have been labeled a sensitive place by the state of Texas? I don't think so. And basically, this is exactly what the plaintiff is arguing in this case down there. This is what they say next. The locations at issue here cannot be analogized to the very few and very different locations considered sensitive at and around the time of the founding. Specifically, laws from the colonial and founding eras that the government comprehensively secures, as illustrated by the Founding Fathers' laws barring carry in polling places, legislatures, and courthouses, as well as the broader affray tradition, indicate that firearms can be banned in locations. One principle seemingly underlying these historical regulations is that carry may be restricted in certain highly sensitive locations, such as courthouses, and listen carefully, folks, where the government has taken the burden of security upon itself and the need for self-defense may be reduced. So there you have it, folks. They're essentially saying that the only way the state of Texas can make you put away your guns and declare a place a government-mandated gun-free zone is if the government itself takes upon the burden of protecting you with their own guns, their own security, their own metal detectors, their own fences, their own limited points of entry, and arguably takes on the legal liability if something bad happens to you in the same way that if they put you in prison or took you otherwise into custody. And I don't think Texas is going to be able to do that here in the context of private bars, racetracks, or sporting events. But anything's possible, and we will see what happens. So there you have it, folks. We wish the Firearms Policy Coalition good luck in their case down there in federal court in Fort Worth, Texas. And we will keep you apprised as things develop. In the meantime, check out my article in the Georgetown Journal of Law and Public Policy, linked to down below. Don't forget that on Saturday, I will be speaking at the Federalist Society alongside some very prominent people, including U.S. Court of Appeals Judge Amal Thapar, a very smart guy. He's been on this channel before, talking about the Second Amendment. Make sure you check that out. The Federalist Society, I'll put links to that out on my X feed at 4Boxes Diner. And again, please follow me on X at 4Boxes Diner. We have over 19,000 followers. Make sure you subscribe to this channel. We're trying to get to 200,000 subscribers at some point soon, we hope. And make sure you like this video and feel free to share it and give it to others so they can learn about the Second Amendment as well. And we will talk to you again very soon here at the 4Boxes Diner. Look forward to it.
Orders up. Table 2A.